Welcome to an exclusive discussion with Mr. Rajeev Amarasuriya, the former Secretary of the Bar Association of Sri Lanka and the President candidate for the 2025 BASL elections. I'm Nimna Pereira, representing Pramuka Law School. Today we have Mr. Rajeev Amarasuriya to discuss about his vision, policies, and the future of legal professionals under his leadership. Thank you for accepting our invite.
Thank you, Nimna.
As someone who has served as the BASL secretary, you have had experience in leading this prestigious organization. So, looking back at the past experience, what are the key contributions that you take pride in?
It's an interesting question because I actually came forward for the post of secretary in the latter part of 2019, and I met the membership. And I presented what I was going to do. And on the 27th of February 2020, it was one may call it a landslide win, but I was elected as the Secretary of the Bar Association. So we have, though the election is on a particular day, the date of assumption of duties is about a month later. So I was scheduled to take over as Secretary of the Bar Association on the 28th of March 2020 at the formal first Bar Council meeting and at the convocation. But if you remember, in 2020 in March, on the 14th of March, the country went into a lockdown. Everything as we knew it stopped being so, and people were at home. But the then office bearers of the Bar Association decided that since I had been elected won that election, that I can still assume duties even though there was no ceremonial function or meeting. So on the 28th of March, we had to obtain curfew passes, go to the Bar Association, open the office, light a oil lamp. I was asked to sign a document. We knocked the oil lamp off and came back home. For about 2 months from that date, we were all at home. The BSL was not fully ready for the staff to work from home. There was staff of about 30, and it was in that situation that I had to assume duties. But I thought that you can't just, there may be challenges posed to you, there may be difficulties, but the easier thing is to say, well, how can we do anything? We wait till the problem solves. But I think leadership is about dealing with problems, dealing with challenges, and finding solutions. So I was immediately, from day one, thrown into the deep end. I was not a previous office bearer of the Bar Association. I was received the task of having to turn around what we did usually and convert to a new normal. So it was obviously communication channels had to be changed. We had to look at reaching out to the membership, and we had to find ways and means of doing what we used to do in a different environment. So I had anyway in my action plan before I came forward for the presidency at the time, I had presented this proposal that I was going to convert all of the legal education activities into the hybrid mode so that there will be more reach to our membership. And that was because when I went around the country and met the membership, something I was told was that, there are a lot of programs in Colombo, but maybe we are in, somewhere far away from Colombo. We do not have the benefit of all of this. We feel distant and we feel isolated, and that there were some members said, well, our branches, we feel like becoming independent from the mother organization. So I realized that if sometimes in Colombo you might have a house full at the auditorium and maybe 100, and you'll be happy. But what we forget is there are, say, 24,000 members, 100 are in the hall, which means there are 23,900 who are not benefiting from what we are doing. So I thought, and I had presented the proposal that we would take it digitally. So when I was thrown into the deep end on the 28th of March, immediately we decided that we will go ahead with online teaching, online learning, and taking our work forward. So we launched the BASL webinar series. It was not, as I said, because of COVID, it was a plan, but we started it fast. And during those 2 years, we did 175 BASL webinars, which is accessible not only to our membership, but anyone, even today, because it is uploaded on the BESL YouTube channel. And now I find that out of the 175 webinars, most of them have been watched at least by, sometimes by 15,000 people, which means there is an absolute repository of legal learning, legal knowledge, which is now embedded in the BSL YouTube channel with all of this learning. So that is something which I was able to change, and to supplement that, we started the online certificate courses, where when we used to have previously 100 members in the auditorium, here we were reaching out to 400. And we in fact had our members from places like London, Singapore and Dubai joining into the program. So I take pride in being able to convert the traditional programs we conducted, or the teaching we provided, legal education, into this virtual mode, which is now, I'm happy, continued to date. And also it's a huge income revenue generator also. So whilst most of the organizations fell into, one might use the word darkness during that period, the BSL, during the time I was secretary, sadly, and that is said across the membership, had a new life, so to speak, and a lot of activities happened. Of course, in addition, there were a lot more things we did. It was a new normal. So everything, and I'm happy to say that during my term, and that I take pride in, that everything which traditionally happens at the Bar Association in a year or 2 years happened uninterrupted during the term of my term as secretary. Whether it is a national law conference, we had 2. Whether it's a junior national law conference, we had 2. Whether it's a newsletters, actually the newsletters had stopped being circulated a few years before I started. That also we did during the period of the most difficult time for this country and the world. Whether the diaries came on time. I mean, I don't think there were any complaints on the work we did. And that is something I take absolute pride in.
Legal profession, as any other profession, face continuous challenges and demands. According to your perspective, what do you think are the pressing concerns of the legal community today, and how would you address those?
Yes, Nimna, now that is a very broad question you're putting to me. And if you want me to give you a comprehensive answer, I might have to speak to you for a couple of hours. But I'm sure you expect me to cover this in 3, 4, 5 minutes, and I will try my level best to do. We are very proud of our legal heritage. We have a legal system which has a lot of tradition from beyond the shores of Sri Lanka, and of course also built up over the years in Sri Lanka. Having said that, there are also, and we must be comfortable in saying that there are areas for improvement. Everyone speaks of laws delays, and we must accept that there are laws delays. So in respect of these delays, and it actually got worse because of the COVID, the stoppage of work during COVID, there is also a need to secure more resources for our system. Whether it is more courthouses, whether it is more judges, whether it's introduction of technology. Now, if you look at, you don't need to look at outside Sri Lanka, look within Sri Lanka. Most of the things we do today is technology based and technology supported. And now a lot of the things are also getting the support of AI. Now, if you look at our legal system, we have the introduction of technology has been very slow. We have certain model courts, and there are certain concepts, but across our legal system, we don't see the usage of adequate technology. Now we have, I'm just taking a few examples from here and there. We have very advanced transcription technology. If you look at on any TV channel or so, automatically the transcription is there. It may not be perfect, but it is there. Now, still our stenos in court take down the proceedings manually, and then of course it takes time, but they have to go back, they have to type it, and they have to then release it. So it's a long process which, if a human is involved, takes a long time. So a simple example, if you have, for example, transcribing technology introduced, at least 80% of what takes place gets transcribed. Then of course the steno will have to spend only a lesser amount of time, maybe 20% of the time normally used, to correct what has been presented and of course release it. A simple example. Then if you look at, I'm just talking about efficiency, effectiveness of court, and I said technology is one way. Also, we must look at some, common sense solutions, because I mean, obviously there are more cases than can be physically managed by the judges. And the judges in many courts from 9:30 they sit till 4:30, 3:30, 4:30, some even beyond. So the work is being performed, but the speed at which justice must be dispensed does not happen because it's physically impossible. So you need to strengthen the hand of the judiciary. Now you asked me what are the problems in legal, and I said I can speak for us. We have problems, lawyers have problems in court registries. There is a complaint, and that is a valid complaint, that there is a lack of uniformity. I'm speaking about land registries, lack of uniformity. Then there is a lack of, proper facilities. You can't get your, certified copies on time. You can't obtain your, the filing. There are, issues with land registries. Court registries, what I spoke of about the technology. If you look at if you look at it from a broad perspective of our entire legal system, previously, say the law faculty from where I came there was a time when it had maybe 15, 20 graduates coming out. During my time, there were 200. Now there are about 350 a year. Now we have a lot of other avenues of entry. We have the law college, which is also now more. We have the foreign universities, the local universities affiliated to foreign universities. We have the Jaffna department, the Peradeniya, we have the KDU. So large number of students come in to the legal, convert and become lawyers during the year. And that large number, previously the tradition was you go to a senior, you work with a senior for a few years, you learn. But because of the large number coming in, and that could be 1,000, 1,500, 2,000, now there aren't adequate seniors to provide for all of these numbers coming in. So on one hand, the Bar Association has an important role to address this issue. Since we have, obviously, if the numbers don't match, you won't have adequate seniors being able to train and mentor the juniors. I mean, it is not possible. You might have maybe 5, 6, 10 juniors, but beyond that, even a senior won't have time to spend on the junior. So the Bar Association, in my formulation, has to fill this gap. And obviously it won't be on a daily basis, but that gap of, knowledge, values, practices, traditions, being able to answer a question. I mean, as a young lawyer, I had 100 questions. I mean, some of those you can put to your senior, but seniors won't have time. So answer those questions, have feedback. So that gap the Bar Association must fill. It can be, part of it can be virtually. We can use the BSL premises for, young lawyers to come, senior lawyers to come. So that whole transition must take place. And we need to ensure that our young lawyers have the knowledge, the capacity, the capability, because that's the future. And we all, from the time we were in school, we say you must invest in the young, the future. They are the future. The young generation is the future of this country. So if we mean what we say, we have to spend time on the juniors, who are going to be our future of the legal profession, also future of this country. So I mean, I can go on. The one area. Then there are, there's just a few things which come to the top of my head. But there are a lot of areas we need to uplift, we need to develop. Some areas we need to also rethink. Our legal system goes by, we have a lot of, procedures. We follow what was brought to us by the British. But we find that some of what was given to us during British times has changed in England. And in England, they don't do that anymore. But we are still following those procedures, practices. So we must simplify things. We must make things easy. And we must also ensure that we have dispensation of justice efficiently. Another little offshoot of this is that with the change of this economic crisis and in the price of things going up, litigation also has become expensive. And I am not saying only about the lawyer's fees, and that's something maybe you can, depending on the client, that might be adjusted, but also because of the fact that our court system, our justice system still is paper-based. There's also a cost involved in paper. And sometimes, I had once a client who, not too long ago who had a very good appeal. And I said, this appeal is a good appeal and the chances of success are very high. And then, of course, he asked what my fee was. And I said, I quoted a reasonable fee. And I said, this for me, this is my junior and so on. And then he said, it was difficult for him to bear. But then I said, no, it's okay. I won't take your fee. I don't want a fee. We will not take fees, but we'll do this for you pro bono. But you might have to bear the cost of other costs. And in fact, I spoke to the Legal Aid Commission and I said, there is a client who's finding it difficult. And they agreed that they would provide legal assistance. Of course, it was also said that if they will provide, but the client would have to bear the cost of photocopying and printing. And then I asked how much, and we looked at number of pages. We had sent copies to all the respondents, and we calculated maybe into 10 rupees a page, and we said maybe about 60,000. The client said, well, that is also too much for him, and that he will not appeal. So that is the reality of this of the present situation. So digitalization, automation would also provide the cost to come down. As opposed to printing 25 copies, you might have one. You might upload it or email it to the other side, and then they can print. So those are areas we need to all look at.
Regarding the concerns that we spoke right now, there have been concerns regarding the renewing of the practicing license of the young lawyers, which we saw that you have objected, and also regarding the Supreme Court rule and the suspensions of the lawyers, which you have made proposals on. So we would like to know more about this.
Yes, you have put several matters in the form of one question. Let me respond to it separately. In point of time, the first matter is in relation to Supreme Court rule matters. And there was a bit of an outcry in our profession because there were a few suspensions of lawyers for a relatively longer period of time. Certainly there was some wrong they had done. So there was various views expressed. On the 1st of November, I addressed my representation and letter to the Bar Association, setting out what I proposed as being what BSL should work forward to. One thing I proposed, which was at the forefront of my representation, is that at present the disciplinary control of the Supreme Court, the disciplinary control of members by way of a Supreme Court rule matter is vested in the Supreme Court. Certainly the Supreme Court enrolls and admits and disenrolls members, but the inquiry into a disciplinary conduct issue is also now placed before the Supreme Court. One of my proposals was that in terms of the principles of natural justice, for any decision, anything which is adverse, one must be entitled to at least one appeal or review. And by having this particular jurisdiction presently in the Supreme Court, the problem we have is that the Supreme Court in this matter would be a first instance of jurisdiction also, but it's the final point of jurisdiction because there is nothing above the Supreme Court. So I have recommended and requested the Bar Association to do whatever it can and lobby that this particular inquiry process is taken out of the Supreme Court and placed either in the Court of Appeal or in another tribunal, so that in the event that there is an adverse order, it can be both ways, that there is one appeal or review to maybe the Supreme Court or some other body. So that is one important request I have made, because maybe what has happened, but we need to address that as well. But going forward, we need to have one tier of appeal, and that I say is something which the fundamental principles of law require. In addition, I have said that these rule matters are not public hearings. These are matters of discipline of attorneys at law, and this must be something held in camera. Camera is where only the parties would be in the room, and that would be argued. It does not have to be in open court where there is no need, there is no purpose in doing so. So that is my proposal. Essentially, there was a few other ideas, proposals, but this was the main two which I have presented. In respect to your question on the practicing license, about 2 weeks ago, the present Bar Association called up a special general meeting, like extraordinary general meeting of the Bar Association, to amend the constitution on certain matters. One of those matters was to introduce a new object into the constitution of the BSL, that is to coordinate with the Supreme Court in any scheme that may be put forward for the grant and renewal of practicing licenses to members. Now, I objected to that proposal by the Bar Association on several folds. One is that at present, it is obvious, it appears to be premature because there is no scheme which the Supreme Court is speaking of to license lawyers. So there is no need for the BSL to get excited about this. We'll have to deal with it if there is such a proposal which materializes. Secondly, a matter of the nature of a license is something which hits or affects every single member, because as of now, when we are enrolled by the Supreme Court and admitted to practice, that is a license we have to practice in any court in the country. Now, if the Bar Association is going to get involved in some process which speaks of licensing, that could be annual, that could be every 5 years, we don't know, we don't have details of how it will be put across, then that is something which affects the very right, the basic right and entitlement of every attorney at law in the country to practice. And if you are going to have some limitation on the practice, then if the Bar Association is getting involved, then it is only but fair that every member of the Bar Association is given an opportunity to raise either to agree to it or object to it, and one must stand with the majority. So that was another ground upon which I objected, saying that if you are going to do this, then you must ask the membership, and the membership must be aware as to what the parameters and the scope of this licensing is, whether it will apply to everyone, whether it will apply to some. I mean, I don't think the Supreme Court will allow licensing to be applied only to some and not the other. It will be a violation of the basic principle of equality we find in the Constitution. So I don't think the Supreme Court will do that. So it is something which will have to apply to everyone. What do you test? Do you have to go for some test? Do you have to go for, I mean, there is a proposal that you must go for these seminars, you have to gain points. How does it work? And one must know this. Thirdly, I objected on the basis that, certainly everywhere in any profession, in any community, there may be those who don't do things perfectly. There may be complaints, and there are complaints against lawyers for not performing their services properly. I mean, that same complaint you get against doctors or engineers or surveyors or any other profession. So just because you have that in respect of a few, does that justify licensing everyone else is doing a proper job and role? So to me, that doesn't match. And if you want to, and that doesn't really address the problem. The problem we have is that we must upskill our lawyers. It does not have to be a forced upskilling. I mean, all members would be interested in learning, specializing, and that process must be provided. And that is what you call continuous professional development. When I was secretary, we had 175 webinars, we had a large number of symposiums, we had conferences, we had certificate courses, we had every type of education learning we can provide. And that is continuous professional development. A large number, the certificate courses in period 2000, 2002, 2000 plus members participated. That's about 10% of our membership. The webinars, if you go and look at the number of views, each webinar, I can see, and all of us can see, that has been watched by at least 10, 15,000 people. Many of them would be lawyers. So there is CPD taking place, but maybe it must be more structured. So it is in that context that I objected. I don't believe that licensing of members is something which can happen now, which should happen now, and there is no justification for that. The BSL simply, I simply could not understand why the present Bar Association put a proposal like that forward, because it is not fair by the membership, it has no basis, it has no legitimacy, and it has no purpose it seeks to achieve now. So that is not something we must look at. But in the next 2 years, if I'm elected, we will have even more focus on continuous professional development, of course, without licensing. And I will object to any scheme of licensing sought to be imposed on our membership. That is not something we need at this juncture.
In a climate where institutional independence is scrutinized, how would you ensure that BASL ensures to be independent amidst the social and the political pressures?
Yes, the BSL must be independent from all aspects. Simply speaking, the BSL must have the strength to say wrong to what is wrong, and also have the strength to say, well, it is right to something which is right. And to me, that is staying in the balance. Independence can be interpreted in many ways. Political independence, of course, we must be apolitical. We must, I mean, each one will have a political view. We ultimately, 80% of our population votes. So everyone has voted for X or Y. So you have some preference, and that you cannot never take out the system. But when you take on the role of president of the Bar Association or secretary of the Bar Association, you need to be independent of those ties. You might have even more closer ties. You might have, those you know. You might have those, you're related to. You might have those, you might be involved, you might have connections to other groupings. But all of that must not be there when you make decisions for and on behalf of the Bar Association. Also, like many other groups and associations, even within our Bar Association, we have seen little groupings from time to time form. And I believe that a president of the Bar Association must be also independent of those groupings, because when the membership elects you as president, it is the confidence the membership has in you as being president, and that reputation you must carry. I don't think there is one allegation against me that I was not independent during the term I was secretary, and that was not an easy time. That was the time of the pandemic. That was the commencement of the economic crisis. In fact, the historical statement on the economic crisis, which the BSL issued early in 2022, was under my signature. So independence, I say, is in that respect. And independence, I mean, you will see, I mean, it's very easy to see if someone is not independent, because your actions will show. And I'm not shying away. We have had instances, we have had office bearers in the past, from time to time, who have sometimes not been independent, but as soon as that happens, the membership will come up and say, well, you are not independent. And then you go back to that status of being independent. So that is vital and essential.
Thank you, Mr. Amarasuriya, for joining us today with this valuable discussion. And thank you, dear viewers. Stay tuned with Pramuka Law School for more informative discussions. Stay engaged, stay informed, and let your voice be heard. Thank you.
Thank you.